My name is Teresia Gito. I will be taking you through this topic. And I'm going to share the screen on our syllabus and how far we've gone and how far we intend to go today. This is our current syllabus, what we have been using in the previous lessons, what we intend to use today. So far we have covered the nature, the purpose, and the application of law. And we are currently in topic 2 on administrative law. Our previous class covered the principles of natural justice, as well as the judicial control of the executive and the independence of the judiciary. So for today, we had not covered the sources of administrative law. That is where we intend to start on today's class. We are able to cover up remedies in administrative law for mandamus, statutory prohibition, habeas corpus, injunction, and declaration. Once we have covered that, we'll have effectively finished the introduction to the basics so that we're able to move to the court system. As I was saying, we were able to cover administrative law. We covered its meaning, whereby we said that administrative law can be defined as the law relating to public administration that relates to the executive branch of the government and how the government carries out its tasks. We also carried out, we talked about the functions and the purposes, whereby the very essence is founded on the Constitution, and why we have administrative law is that the citizens are protected from abuse of power, and it keeps the government of the day in check. And it ensures that the duties placed in public bodies are performed, and where they are not performed, these agencies can be compelled. And this is what we will study in the remedies. That what happens when a public institution is expected to do something, and they do not do that which is expected of them. Where do we go back? We go back to the same constitution that gave them these powers. We go back and find out what has the constitution provided. Again, it seeks to protect citizens from the abuse of power. So when we feel as the citizens, as the owners of the constitution, that these powers have been abused, how do we go about ensuring that we seek remedies? We talked about the doctrine of the separation of powers, whereby in Kenya we have 3 arms of the government, and each is kept separate to ensure that they check each other. We have the legislature, the executive, and the judiciary. While one creates the law, the other implements the law. And each is expected to maintain its independence. In which all are bodies of the same government, one is able to ensure that the other, they check each other. And they exercise different functions. And can be a member of more than one organ. These are constitutional offices, again, provided for in the 2010 Constitution of Kenya. They provide these 3 and who are members. We talked about the independence of the judiciary, whose function is to administer justice, and it must operate impartially and in an unbiased manner. This is why the government, in its passing of the laws, can be taken to court. We have seen the current finance bill was taken to court, and it was able to be discussed, and the court issued its orders. Without this, it would mean that any arm of the government can act without any regard to the will of the people. And this independence of the judiciary is also whereby if your rights as an individual have been interfered with by any other arm of the government, this is where you go to seek redress. We talked about how the judiciary should be independent. And how do we ensure this? One, they are given immunity from court actions for actions taking place in the course of judicial proceedings. Their tenures are provided for. There is security of tenures. And we have Chapter 6, whereby before you are appointed, you have to have ensured that Chapter 6 of the current Constitution, all are ticked. You are a person of high moral integrity. You have no cases. Your character is held to the highest esteem that can be thought of. That if you are placed on a weight, on a scale, your actions of morality, integrity, and good behavior outweigh any other issue that may arise. So why do we have the judiciary, and why do we insist on its independence? Because it promotes the rule of law. It ensures that the laws that are passed are for the benefit of the people, and it checks the state. That is why we're able to see the acting Inspector General is summoned to court, and the rest that will play out. Most importantly, it upholds the Constitution. We have talked about the Constitution being the supreme law of the land. So whatever happens, the Constitution must be upheld. We then talked about natural justice, what natural justice entails, and the principles of natural justice. And we said that they're implied and they're applicable in the absence of statutory law. Remember, we had talked about the common law, the courts in England, and they are part of the common law principles. We talked about the application of natural justice. In it, we looked at this case of Mirugi Kariuki versus the AG. Mirugi Kariuki had requested for a Queen's Counsel to come and represent him, and his application was denied. But he felt that his rights had been infringed upon because, one, he was not notified, and two, no reason had been given as to why his Queen's Counsel could not represent him in a Kenyan law. And the Court of Appeal upheld that, yes, his rights of natural justice had been interfered with. A decision needs to be given reason. It cannot just be given. And that is why we have these decisions published in the Kenya Law Reports. They're also available physically, whereby it is not just the case has been heard and determined, you are found guilty. No. They give the basis for each decision made. And they give, on top of giving the reasons, they support it with case law, they support it with facts. Once this is done, you're in a position where you feel you as an individual, you have been able to, your rights have been upheld. And we talked about the principles of natural justice. The case of Mirugi Kariuki is this, audi alteram partem, no person shall be condemned unheard. So for him, denying him a chance to bring the Queen's Counsel was tantamount to condemning him unheard. He needed reasons. Why couldn't he have that representative in a Kenyan court? We finished with the rules of natural justice, the principles, these two, nemo judex in causa sua, the procedure shall be free from bias, and no person shall be condemned and heard, are further broken down into these ones, where we have the rule against bias, and we have the right to be heard. We have prior notice. In prior notice, we talked about if you're arrested today, you will not be taken to court and the proceedings, and you have your case heard and determined tomorrow. You'll be taken to court. Your charges will be read against you. You'll be given a chance to accept or deny. Once that is done, a date will be set where you'll be given a chance to prepare your defense, a chance to put your affairs in order, so that if right now I have taken you, George, to court, and I have said that, George, we had a contract, you are to deliver maybe 100 bills of unga, you did not deliver the 100 bills. Tomorrow morning, we cannot go to court, and I will not ambush you. I will be told to produce the contract. You'll be given a chance to look at that contract. You'll also be given a chance to prepare your defense. And I will also be given a chance to look at the documents that you prepare in your defense. That is prior notice. Nothing can be done immediately without giving you that chance to prepare. That is close with the opportunity to be heard. We have talked about Mirugi karaoke. You must be given a chance to explain yourself, that if you're brought to court and a case is against you, you did, as we have talked, George, you did not complete the contract. You will be given a chance to explain yourself. There's the disclosure of information, again closely linked with prior notice. The courts do not encourage ambush. They provide that whatever document, whatever witnesses you'll rely upon, you give the other party a list of the documents you intend to produce, so that they're also able to go through them. They're also able to question them. So case in point, we are talking about that contract that I entered into with George. And George says, no, I never signed this contract. So if I'm going to introduce a person who is well versed with forgery, George needs to be given a chance to see that this person I am introducing, he can question his credentials. He can question his ways or methods of proving that this person is actually competent. Adjournment. We talked about this case of Pridle versus Fisher and Sons. It talks about if something happens that puts you, an emergency happens, you cannot be denied a chance for an adjournment. Be denied a chance for an adjournment if, say, for example, you fall sick on the date of your hearing. You are allowed to go to hospital. The case cannot be had against you because you are unwell. Of course, there are limitations to how many times you can say you went to hospital. Eventually, it will be thrown out if each time your case is being heard and you're not there because you're unwell, investigations will be done whether you're taking advantage of that. And for each time that an adjournment is raised, there must be sufficient grounds. It's not done for the sake of doing it or to extend the court process. It's a principle of natural justice that you allow someone to be in their best, emotionally as well as physically. Because if you're admitted to hospital, you cannot be brought in an ambulance to hear a court case. It will be adjourned until you're well enough. We talked about cross-examination, whereby your witness, I am allowed, once you present your evidence and you take him through the examination, I will cross-examine him. I will ask him questions that will help build my case. It is a principle of natural justice. We talked about giving reasons. And finally, we talked about legal representation, where you're allowed, you can represent yourself if you feel you're able to do so, but the law provides, the principles of natural justice provide that you're entitled to an advocate. And this is where the Law Society of Kenya comes in. You hear of them taking pro bono cases where they feel, or any other advocate feels that this person is not prepared, is not able to represent himself. He may not have the financial muscle or financial ability to employ someone to do that for him. So they take up cases pro bono. Therefore, you're legally represented.